by this court. If you are unable to engage in sexual penetration and produce a child, you need to be able to take care of that child.
So the defendant in front of Judge Elmore today decided to move to Oklahoma, start a new life, but not take care of his support obligations back in Michigan. So he's back in Michigan because they brought him back. And he told the judge, well, you know, I'm sorry, but for 5 years, I just couldn't figure out the court's phone number. Meanwhile, he racks up $64,000 in arrearages. So that's what Judge Elmore is dealing with today. Take a look at how he handles it. Let us know your thoughts in the comments. My name is Dan. This kitten sitting next to me is Ellie. This is the Courtroom Files.
Stapleton, do you have the old PSI for this file?
Yes, sir.
Mr. Burke, if you can hear us. There he is, everybody.
Good morning, Your Honor. Sorry about that.
It's okay. All right, we are now on the record today on this Friday, March 27th. Going on the record now for the 28th Circuit Court here in Wexford County. Our first file this morning is People of the State of Michigan versus Henry Collins. The file number in this case is 19-12592-FH. Appearances, please.
Your Honor, good morning. For the record, my name is Mark Burke. My P number is 54935. I'm with the Attorney General's Office, praying for the people.
Thank you, Honor. Taylor and Anna Prevento on behalf of Mr. Collins, who's present in the courtroom.
Thank you. All right. Also this morning is Mr. Kevin Stapleton. He is the agent today, who has been the probation agent on this case since it began back in 2019. He is here before the court, and we're here today for a probation violation hearing. Let me take a quick look here at the history of the file. Looks like we were last here on the record last week on March 20th. That's Friday. Then it requested a hearing to be conducted within 14 days. Bond was denied. He was remanded into custody. Looks like that was actually the informal hearing, the second hearing after we conducted an arraignment on March 17th. So we're here today for a formal hearing. All right, Mr. Burke, have you had the opportunity to speak with, you know what, I don't like it when I say have you had the opportunity. Everybody has had the opportunity. Have you actually spoken with the prosecutor? I'm sorry, the defense attorney on the file.
Your Honor, counsel and I spoke last week in a breakout room, and we talked about a couple different options. I'm not quite sure exactly what the defendant's position is today, but I did speak with counsel last week about, like I said, a few different possible options to resolve this.
All right, so what are the answers? Mr. Avento?
Thank you, Your Honor. Today, my client would be prepared to move forward on a plea to the offer extended last week by the prosecutor, and I have met with my client in this since our last hearing. We met at the jail. We met again this morning. Sorry, the radiator is quite loud.
That's all right. Keep going. So what's he going to do? What's he pleading to?
Well, Your Honor, we would like to plead guilty to count 1 and count 4, which was the allegation that my client was convicted of new offenses in the state of Oklahoma. We ran into an issue this morning, though, talking to Mr. Stapleton, is we are not sure if the records Mr. Stapleton has would be sufficient for purposes of that or with the court. And I would like to be able to talk to the prosecutor about that, or ask the court how they'd like to proceed on that issue.
So, one moment. So there were a total of 4 counts. The original alleged violation was filed in this file on January 13th of 2001, alleging that on November 6, 2020, the defendant had violated a criminal law of a government, specifically the government in Oklahoma, for a case of child neglect. That's one of them to which he would plead. Count 2 and 3 are that he failed in effect to report from January and February of 2021 for a period of more than 60 days. Therefore, there would be an absconder status. And then count 4 is the violation for count 1. I'm sorry, rule 1 again for violating another law. That one was possession of methamphetamine in the state of Oklahoma back on October 21st of 2020. I don't understand here. I'm going to boil it down this way. He's willing to plead guilty to 2 out of 4. All 4 are non-technical, which means whether he pleads to 1 and 4, 2 and 3, or any combination thereof, it's the same result. Mr. Fiorvento, what does your client wish to do? To which ones are you going to plead? And he's going to make the statement that he knows whether or not he was convicted or not convicted. He also knows whether or not he has or hasn't had any contact in 5 years.
If the court will allow him to just testify that he was convicted in Oklahoma and that testimony is enough, then we would want to proceed forward, pleading guilty to count 1 and count 4.
All right, got it.
Thank you.
Mr. Burke, are you okay with that?
Yeah, the people would be satisfied with the defendant offering an acknowledgement as far as like the factual basis for the plea. That's fine, Your Honor. Yes.
Thank you. Mr. Collins, is that what you want to do today?
Yes, sir.
All right, to the best you can, please raise your right hand for me. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, sir.
You may lower your hand. All right, Mr. Collins, I covered a little bit just briefly there a moment ago what the 4 counts are, and I covered them last week. Do you need me to repeat them to you?
No, sir.
Now, by pleading guilty to count 1 and 4, which again are the allegations that you were convicted of a child neglect in Oklahoma and convicted of possession of methamphetamine in Oklahoma, you're not going to have a contested hearing. You'll be waiving the right to question or cross-examine any witnesses against you. You'll be given up the right to be presumed innocent until the prosecutor proved beyond or by a preponderance of the evidence that you were guilty of those. You'll also be given up the right to confront those witnesses, present witnesses, evidence for testimony yourself. Plus, you'll be given up the right to remain silent and the right to not have that silence used against you. Do you understand?
Yes, sir.
And once again, because in this original case, you were convicted of failing to pay child support, if you are found guilty or I accept those pleas, you'll be facing resentencing on the original offense, which is a felony punishable by up to 4 years. Do you understand?
Yes, sir.
And has anyone made any other promises, threats, or inducements that we haven't talked about this morning on the record to get you to enter this plea?
No, sir.
Are you making the plea of your own free choice?
Yes, sir.
All right. Now, there is one more thing I realized I failed to mention to you. I know there was an extradition to help move you from Oklahoma out here to the great state of Michigan, and probably what is the best time of year to be here and to probably be inside. But anyways, you could also be reassessed that cost for that extradition fee. Do you understand?
Yes, sir.
All right. Knowing all that, do you still wish to enter the plea of guilty as we discussed?
Yes, sir.
As to count 1 of the requested warrant for probation violation, which again asserts that you violated condition 1, not to violate any criminal law of any unit of government, and that specifically it's based upon a finding of guilt for a case of child neglect out in Oklahoma. How do you plead?
Guilty, Your Honor.
And as to the count 4, again, violating the same rule or condition number 1, not to violate any criminal law of any unit of government. And that one applies to that you pled guilty for the possession of methamphetamine in Oklahoma. How do you plead?
Guilty, Your Honor.
Mr. Collins, first, the court takes judicial notice of the terms and conditions of probation that are contained in this file, and they were issued by my predecessor, the Honorable Judge Elmore, and was then subsequently signed and acknowledged by the defendant. Judge Fagerman signed it on October 29th of 2019. Mr. Collins signed it, looks like on exactly the same day. Sir, is it true that back in, hold on, I gotta find the right date. It's like back in Oklahoma on or about November 6th of 2020. You were convicted of a charge of child neglect, which is a criminal statute.
Yes.
All right. And did you enter a plea to that, or was there?
Yes.
Okay. And how did you plead?
I pled guilty.
All right. And sir, is it also true that subsequently, on or about October 21st of 2020, you pled guilty to a charge of possession of methamphetamine, a criminal statute in Oklahoma?
Yes.
And again, you pled guilty to
Yes, sir.
admit that. All right. Thank you. Mr. Burke, you believe you provided a factual basis?
The people are satisfied, Judge. Yes, thank you.
Are you aware of any other promises, threats, or inducements?
None for the people, Your Honor. Thank you.
So far, do you believe that I've complied with Court Rule 6.445?
And the people are satisfied, Your Honor. Yes, thank you.
Thank you. Ms. Fierabento, do you agree with all three?
Yes, Your Honor.
Great. The court agrees as well. I find that the plea today has been made freely, knowingly, and voluntarily. I further find that the testimony provided by the defendant under oath on the record, in addition to the judicial notice of the terms and conditions of probation, that the defendant is guilty of counts 1 and count 2 on the 2 requested warrant for probation violations. Counts 2 and 3 are therefore dismissed. Mr. Stapleton, can we proceed with the sentencing?
We can, Your Honor.
Mr. Burke, any objection to that?
No objection, Your Honor. Thank you.
Ms. Fierabento, any objection? Keep in mind that if we did sentencing today, that means I'm not ordering an update, which means prison isn't going to happen.
We would like to proceed forward with sentencing today, Your Honor.
Great, thank you. All right, Mr. Stapleton, let's go over your recommendation.
Thank you, Your Honor. The defendant was originally sentenced October 28, 2019, to a 2-year probation term. He had 150 days jail with 110 days credit. He was immediately transferred to Oklahoma, which is where the state which he was extradited from for this case of child support. He was supervised in Oklahoma. He was obviously violated probation on a couple different occasions, then absconded from probation supervision for a number of years, and here he is here before the court today. According to my calculations, he has 127 days credit. That's the time that he was
Actually
actually
sat, not good conduct time, but
no, not including good time. No, I'm sorry. That would be without good time.
yes, what I'm
Yeah.
sorry. Keep going. Let's stop talking, you and I. You just keep going yourself. You're doing a better job than I am.
Anyway, it'd be my recommendation that probation be revoked. The defendant be sentenced to a lengthy term of jail. All fines and costs preserved, and as well as child support. There's also a restitution request from the state of Michigan for this recent extradition, which is $4,108 even.
That's it.
That's it, yes, sir.
Mr. Burke, on behalf of the people, sir, allocution.
So, Your Honor, the couple things I want to point out. The defendant's current arrearage as of this month is $64,328.43. The good news is the defendant does not have an ongoing support obligation, so it's not growing, but it's still north of 64,000. The as Agent Stapleton indicated, sentencing was on October 28th of 2019. Since that date, there's been one reported payment towards child support, which was $70 on February 6th of 2020, and that's it. No other payments. So before that, the latest reported payment before that February of 2020 payment was in June of 2019, before the defendant even took a plea. So I mean, it's naturally the idea of these cases is to have the defendant support his or her child or children, And the defendant took a plea back in September 2019, sentenced in October 2019, and he's made one payment since then, the amount of $70. And he's picked up 2 criminal convictions. The arrears is north of $64,000. As far as the sentence is concerned, Your Honor, I'll leave it to the court's discretion, but I wanted to make sure the court was aware of those figures and that information.
Ms. Fiorvento.
Thank you, Your Honor. My client would respect the request to be allowed the opportunity to try again, and he understands that some period of jail might be necessary, but he has been working to improve things. He's reported to me, he's communicated with his wife. They have figured out a monthly budget and to begin making regular payments on these arrears. He reports that he had some job prospects and he was starting to kind of get things more stable and get back on his feet. He reports that while he didn't report formally, sometime in 2025, he started trying to make phone calls to find the right person in Michigan who he could then start making payments to, but he wasn't really sure where to go or who to talk to. He is remorseful. The court has sent a very clear message being picked up and extradited that this is not something that can be ran from. This is not something that can be avoided. This is something that needs to be tended to until all of this is taken care of. And if he was to run again, it would lead to more arrearage, it would lead to more extradition. It would simply make the situation worse. For that reason, Your Honor, we do respectfully request that he be allowed another opportunity at probation, or that any additional time be kept as minimal as possible, kept in county, and that he be able to somehow get back to working as soon as possible. Thank you.
All right, Mr. Collins, you have the right to make a statement if you choose to do so. That you wish to say, and you may remain seated, whatever's most comfortable for you.
Yes, Your Honor, I know I screwed up.
Uh-huh.
I'm 60 years old. I don't want to live like this no more.
What do you mean by that? Living like what?
Running, hiding.
On your last PSI, you had a job and that's why you moved to Oklahoma. You had met your wife in Texas.
I got a new life.
A new wife?
Yes, the wife I had before is the reason I got the meth charge, so I got a new wife now.
Okay,
I've been divorced and married since then.
all right. So
I
what
got
have
a
you been
good one
doing?
this time.
Yeah, what have you been doing? You also had a child out. Let's do it this way.
Yes,
You also had a
I
child
had a new
out.
job. I had a new job, yes.
All right,
Now I got a new grandchild.
okay. All right, so what else have you been doing? I mean, working, tell me about your work schedule. Last time you were working as a fry cook someplace.
Sonic, yes.
Okay, all right,
And after that, I started working as a maintenance guy at a mobile home place, RV place.
all right,
And I was basically working for my rent then.
okay.
And that's when I got picked up at.
How long you been married this next time?
We got married on the 21st, on 2021. August 16th, 2021.
Anything else, sir?
I'm sorry. I don't
Well,
know.
you don't need
I was
to-
stupid.
You don't need to say sorry to me. This
Right,
is,
I understand.
yeah, I'm just the judge. I just sit here
You're doing your job.
5 days a week and I wasn't even the judge when the case began. All right. Well, this is concerning. Let's be quite here. I don't know what the defendant's criminal history has been since, other than the 2 charges we've talked about. So his criminal history was actually relatively low, at least back in 2019. There was only a string of some misdemeanors. See, in 2009, there was a meth conviction. Looks like that may have been in I don't know which county that was in.
That was in Cook County, Texas, Your Honor.
Yep, there we go. I see. We also had another case out in Cook County, Texas, in 95. Robert while under the influence of 95, and clearly all those would, if he was being sentenced today, those, well, actually, no, there would not be a 10-year gap, but still. All right, well, the big problem here is, Mr. Collins, you haven't made any real effort to make these payments, and it's really easy, and I'm not trying to pick on the attorney, but it's very easy for me to pick on some of the things she said. Why? We've had no progress, and not knowing how to change and find phone numbers and what to do. Mr. Stapleton was the probation officer when this case was sentenced. Mr. Stapleton, you worked at that, in the same office, the same physical spot in this building for how long?
9 years, Your Honor.
Consistently. You didn't disappear for a year and go someplace.
No, Your Honor.
No. You got the same phone numbers. You have the same office space. Yeah, you didn't try hard enough. Plus, this courthouse has been here for 111 years. And while I'm sure it didn't have the same phone number 111 years ago, we still have the same courtroom, the same phone numbers. My predecessor and sat in the same office. Phone numbers for the courthouse haven't changed in decades. So, yeah, you didn't make any effort to make these payments. And you don't need to apologize to me. I'm not the child who didn't get the $64,000 or the spouse who did not get the $64,000. So, plus there was a word that you stated that completely contradicted your attorney. I don't want to live like this because I no longer want to be on the run. Contradicts Ms. Veravento's statement that you were trying to find the right phone number, which of course is on the internet.
I was
Yeah.
trying to find for Attorney General. I found it. I was waiting on a case number.
Well, all you needed to do was call this
Yes, sir.
court,
Yes, sir.
call your probation officer.
Yes, sir.
Yeah, that's the person you should have been talking to. Why? Because my predecessor told you to keep talking to that guy, but you stopped communicating with that guy 5-6 years ago. So, no. So now we're at a point, the child is well over the age of 18. You haven't made any payments. 60 years of age. Yeah, I say you haven't made any. Yep, I know there was like one payment made. And it cost the government $4,100 to bring you from the great state of Oklahoma. Having been stationed at Fort Sill, I can tell you that the word great is in parentheses, especially in June and July. But anyways.
Or August, yes.
Yeah, in August. So anyways, the sentence of the court is as follows. The court terminates probation without improvement. The court preserves all fines and costs, plus the court needs to add to that, Samantha, $4,108 for extradition fees. That's payable to the state of Michigan. And then as for a period of sentence, well, the court looks here at the previous guideline range, which was 0 to 9 months, which we know is an intermediate sanction cell. And the court to be able to give any period of confinement, even though confinement was given by Judge Fagerman back before there were the changes in the law defining what can be done for intermediate sanctions. The court also finds that there are reasonable grounds based upon the continued failure to pay years, failing to comply with probation, committing new criminal activity. Therefore, the court finds reasonable grounds, and that a reasonable proportionate sentence will be that the defendant is sentenced to a period of jail in the Wexford County Jail for 365 days with 127 days of credit. The court considers that while I do recognize that this is about a defendant who may or may not have been able to pay, but it sounds like he's had jobs, and so he's had some ability to make some payments. But even more importantly, the court considers deterrence. We get a lot of child support cases here, and the Attorney General's office and the Public Defender's office do pretty good jobs making opportunities available for people to get reduced charges. And so the deterrence has to be here, and that greatly outweighs allowing time for payment. The message needs to be sent by this court. If you are unable to engage in sexual penetration and produce a child, you need to be able to take care of that child. That's the sentence of the court. Any questions, Mr. Burke?
Your Honor, you indicated that all costs and fines or fees are preserved. Does that include restitution?
I did, including restitution for his pay. Samantha, I need 2 appellate forms, please.
And then, Your Honor, do you need that number again? The balance for any kind of
60
paperwork?
Yeah, hold on, Samantha, write this down. The arrears are $64,328.43. Did I get that correct, Mr. Burke?
That's correct, and that's in addition to the extradition cost of the 4108. Thank you, Your Honor.
Yep. Copy that. All right, Samantha, once you grab those 2 forms, you can take a moment while you're doing that. Mr. Stapleton, here is the old PSI. I'm returning it back to you. You have it over there?
Getting the duck wheel, so.
Okay. Mr. Burke, Samantha's computer is spinning around. Therefore, I'm going to direct, if you could please pick your favorite song from Sesame Street and sing it for us. Ready? No,
You want me to do that, Your Honor?
no, not really.
I don't want to offend anybody.
I know. I appreciate that. One moment. All right. Mr. Collins, Miss Samantha is going to bring to you and provide to you through your attorney 2 copies of one document. You are to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt of the other copy of the same document, which you'll take with you. Now, this document tells you that you have the right to appeal the conviction and sentence in your case, and that is typically done by filing a claim of right to appeal. However, based upon the pleas in this case, any appeal is done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you're going to take with you and return it to the court within 42 days. Thank you very much. We are adjourned.
Your Honor, thank you very much. And Mr. Stubblin, thank you. And Mr. Ferret, thank you. Have a good weekend, Your Honor.
So I am totally in agreement that if you have child support, you should pay it. But I've said it before and I'll say it again. I also think it should be 100% incumbent and required, honestly, on the part of the custodial parent to account for how that money is spent. And there is no jurisdiction that I am aware of where the custodial parent is held accountable. And I think that is a travesty of justice. I don't know if that applies in this case or not, but I think it should happen. Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.